recommendations so as to strengthen our office's capacity in this regard, and created a post of a strategic advisor in this regard, and heightened coordination between the OTP and the registry. And this means that there are three different levels of initiatives being taken. On the one hand, we've got how to enhance cooperation, and we've got a whole lot of integrated teams working on this who are mainstreaming in financial investigation into their investigations, and when they set up the priorities for the investigation. Secondly, we've intensified the network when it comes to different third-party information gathering, such as the Camden Asset Recovery Interagency Network. And this has been very, very helpful in assisting investigators. NGOs are also involved in this. And finally, we have undertaken a lot of work to consolidate the technical capacity at the OTP. In this regard, in particular, for example, we welcome Switzerland's contribution by seconding some of its investigation service personnel to from their prosecutorial office, so as to bolster the financial investigation teams of the OTP. All of this is starting to bear fruit, and this internal coordination and enhanced cooperation between the different organs of the court is starting to bear fruit for the financial investigations, particularly in a framework that respects their respective mandates. So meetings between the two different bodies on cross-cutting judicial issues concerning assets occur on a regular basis, and this facilitates the work. And finally, we welcome the establishment of the National Operational Focal Points Network, which is very positive in terms of cooperation, particularly as concerns on this kind of overcoming the kinds of problems that I mentioned. And this is also a way of streamlining and implementing the ideas that already came out of our deliberations. So now the prosecutor has actually said to especially thank France for its assistance on these financial matters, and it is going to boost the capacity in my office. Thank you very much. Thank you very much, Mr. Barr, for those most pertinent comments. And particularly when it comes to boosting synergies between the different bodies that make it possible to move forward. And now I'd like to hand over to Madame Bertrand from the registry.
Ambassadeur, voici, ambassadeur.
Excellencies, ambassadors, distinguished delegates. At national level, all of these principles have become the core part of addressing crimes covered by the Rome Statute. As you know, the statute states that states parties are under the obligation to cooperate within the framework of identification, locating, freezing, and seizing of assets. This for two purposes. First, the payment of penalties and measures linked to confiscation, and when it comes to paying orders to compensate the victims. So the principle exists in law, but the implementation of this provision is always a challenge for the court, and the states parties have a difficulty overcoming sometimes. As you know, the court, with support from Liechtenstein and the International Center for the Recovery of Assets, in 2015 organized a seminar looking at the challenges to enforce this obligation. This gave rise to a set of recommendations that are just as topical today. The states and the ICC have been working on this. In 2017, for example, there's the Paris Declaration that was adopted, underscoring how important this is. In 2019, the court organized a technical seminar working with experts from the states parties, working closely with them in order to identify the ways and means for states parties to cooperate with the court, the difficulties encountered, and suggestions of how to improve practices. Certain practices used within the area of interstate legal assistance can be replicated, but others are not adaptable because of the specific statute of the court and the Rome Statute. The court doesn't have a territory, does not have financial establishments that are responsible as escrow accounts for a suspect, funds, etc. Certain issues that were still recently just academic matters because of the lack of any feedback from the ICC are now starting to shape up. We see this in the exchanges between the parties and the court and the case law established by the court. The court has now fulfilled an entire cycle of recovery of assets with the first payments of penalties and fines. In terms of case law, it's established in 2016 that the link between assets and criminal activity wasn't necessary for the chamber to order conservatory measures in the framework of compensation cases for the victims. It's also clearly established that the responsibility of taking responsibilities for managing these seized assets falls on the shoulders of states themselves. So, because of the foregoing, the court has gone into an analysis of the details of these types of cases, and it's up to the states also to uphold their end of their obligations under the Rome Statute. Some issues have come out of our communications with states, and I'd like to share them with you now in chronological order. So the first issue that was discussed at length with states is to what extent can states assist the court in identifying property and assets belonging to people covered by either subpoenas to appear or arrest warrants. Can these states carry out a national investigation in order to facilitate the execution of a warrant issued by the court? Now, as we know, this is general language, and sometimes it could be covered by mutual legal assistance, but it cannot give rise to a huge number of requests from the states, and that's why there have to be some preliminary criteria that must be satisfied. It's important to bear in mind the fact that the court focuses on the people who are at the top of the pyramid of perpetrators of the most serious crimes, and that's why, and the capacity of the court to handle cases is very limited, and that's why we have this screening process. Secondly, once the assets have been located, can states take conservatory measures and freeze these assets for the benefit of the victims? Is it possible for states to take measures covering the person's entire assets and holdings, and not only those that are derived from criminal activity? This question takes us right to the serious matter of the types of courts that are on the court's docket and the importance of reparation for victims, according to the Rome Statute. Now, thirdly, once conservatory measures have been taken, are states automatically under the obligation to take steps to avoid the depreciation of the value of these assets and bear the expense thereof? And then at the end of the judicial phase, if there are any sentences and orders to pay compensation to victims, can states in actual practice dispose of the assets in order to facilitate that process? If we look at the form that was prepared during the exchange of consultations on cooperation, it's very useful, especially for the states who are facing charges. I would invite you to take a look at this and visit this on our digital cooperation platform. What we've noted is that the states who have readily enforced the sentences of the court have always done this in a way that solidified their relationship with it. Now, other states have seen that their own judicial authorities were on unsteady ground because of lack of clarity. These procedures must be established in order to maximize the guarantee of the defense's rights in these cases. Any request for cooperation should be carried out in accordance with states' national rules. They can avail themselves of all of the different powers that have been afforded their own law enforcement agencies to follow the money. Now, when it comes to the possibility of the states organize or initiating investigations at the request of the court, or we in the registry have used law firms who've worked pro bono to assist us. I would be remiss if I didn't mention the investigations that the registry is involved in thanks to legal assistance. This falls under voluntary cooperation. We've had lengthy discussions with states about this. So these investigations are focusing on the lack of funds of the person who would require legal assistance. This is assistance that could be provided by states for the recovery of these public assets in the case in which the person unduly benefited from those. So we have to be creative. As I've said, certain states carried out investigations on their own. Others went even further in their implementing legislation. They went beyond the Rome Statute to provide optimum cooperation with the court. So in light of this experience, and to conclude, the registry is pleased to have these operational focal points working in a network who can make it possible for all states to share best practices when it comes to enforcing requests to cooperate with the court. We had a technical seminar a few days ago. We discussed this with several states, and one of the recommendations is that we not duplicate what already exists by way of networks. So the idea would be perhaps take the existing networks and make add to their hats the one of being focal points for the court. Well, thank you very much for that presentation. As everybody will have noted, to have significant results during an investigation, the cooperation of states is of paramount importance. So a lot lies with the states and national efforts. We now hear from Dr. Alejandro Vicente, the legal director of IRES.
Thank you. Thank you very much, Ambassador Bassi and Gueye, for convening this panel, for inviting redress, and for your efforts to promote state cooperation on this important topic. The issue of asset recovery is a core topic for redress. For the last few years, we have been working on the connection between corruption, grave human rights abuses, and the legal avenues available to seize the assets of high-profile human rights abusers to have them assigned where possible as reparations to victims. In 2020, we published a framework for financial accountability for torture and other human rights abuses as a tool for practitioners in this field. The right to obtain reparations, including compensation, is a fundamental right for victims of human rights violations and international humanitarian law. However, victims face many obstacles to realize this right, including the inability to directly access the assets of perpetrators of these crimes. Reparation orders are difficult to implement, and trust funds, such as the Trust Fund for Victims at the ICC, set up to fill the gap when convicted persons are found indigent, suffer from a lack of sustainable funding. While delays in obtaining reparations adversely affect all victims, those in situations of vulnerability, including women and children, experience higher levels of trauma and re-victimization due to the lack of redress. The legal texts of the ICC outline a framework for recovery of assets and property of convicted persons for the purpose of reparations to victims. So far, however, the practical implementation of this framework has not been very successful. The experience in the Bemba case illustrates the complexity of the issues involved. In this regard, additional measures should be taken to improve the ICC's performance in this area. understanding that asset recovery is a complex technical area that requires the allocation of funding and specific skills. There is a need to keep strengthening the capacity of court officials to deal with these matters. In this regard, for example, the International Expert Review Panel recommended in its final report that training of ICC judges includes the law relating to tracing, seizure, and forfeiture of assets. There is also a need to keep strengthening the ICC's partnership with national and international authorities involved in asset tracing and confiscation. In this regard, we welcome the proposal of the co-facilitators to consider setting up a network of national focal points to make cooperation more effective and efficient in this regard. We also note that many state parties are involved in the drafting of the Convention on International Cooperation in the investigation and prosecution of the crime of genocide, crimes against humanity, and war crimes. The draft convention offers a great opportunity to encourage state cooperation in securing the payment of reparations for victims. For that reason, Redress and other colleagues from civil society have proposed the inclusion of provisions on cooperation regarding the preservation of assets which may be used to finance reparations for victims. If adopted, we believe the Convention could also facilitate cooperation with the ICC when relevant. Sharing of knowledge, good practices, and comparative experiences among states and international institutions could also be useful in this field. For example, Eurojust has extensive experience on asset recovery in the context of cross-border and organized crime. And in 2019, it published a report identifying best practices within its casework. Since December 2020, a new regulation applies at the EU level on mutual recognition of freezing and confiscation orders. The regulation recognizes that victims' right to compensation and restitution should have priority over the interest of the executing and issuing states and over the disposal of frozen or confiscated property. There are also some good practices developing at the national level. For example, in 2015, Switzerland enacted legislation allowing for assets deposited in Switzerland by foreign corrupt officials or their close associates to be frozen, confiscated, and restored to the country of origin for the purpose of improving the living conditions of the inhabitants of the country of origin. In March this year, the French National Assembly unanimously adopted legal provisions allowing ill-gotten gains confiscated in France to be returned to the populations in the country of origin. This followed the conviction of Théodorine Obiang, the Vice President of Equatorial Guinea, and seizing of approximately 150 million euros. Civil society also has a role to play. Investigative journalists and anti-corruption NGOs have for many years worked to expose the wealth hidden by corrupt leaders who use oppression to maintain their position of power. NGOs can bring claims on behalf of survivors to freeze assets under Magnitsky sanctions, can seek the repurposing of frozen assets, and can advocate for changes in national laws to make such procedures easier. Were such assets to be made available to reparation funds, they could have a transformative effect. In conclusion, we applaud the efforts of the co-facilitators and encourage states to cooperate in securing the payment of reparations for victims, ensuring victims' rights to reparations are upheld, that perpetrators do not profit from their illicit conduct and do not evade accountability, and that the financial burden of donors and third states to support victims is alleviated. Thank you very much.
Merci beaucoup, Madame Vicente.
Thank you very much, Madam Vicente, for having accepted our invitation to participate in this panel. It's interesting to hear the input from the CSO here. It matters a lot to us, and we will take your remarks into consideration as we move forward on this. Thank you very much. Ladies and gentlemen, I would now like to give the possibility to the participants who are on the list to speak. You realize that we do have very little time remaining. The first on my list is Italy, the ambassador of Italy.
L'Italie, vous avez la parole.
Italy.
Monsieur le Président.
Thank you, Mr. Chairman.
Fellow delegates, ladies and gentlemen, first of all, I wish to express our deep gratitude to the Ambassador of France and Senegal for their excellent, outstanding work, and also reiterate that the position of Italy is, of course, the position of the European Union, as expressed in the European Union statement of the day before yesterday. Here, I would rather confine myself to underline some issues which we deem to be of particular relevance. First, we share the view that cooperation is key in strengthening and enhancing the capacity of the court to fulfill its mandate. Italy is cooperating with the court on investigations in Libya through the exchange of information and documents useful for the work of the prosecutor. The cooperation of states is absolutely indispensable to ensure the court's effectiveness and also to strengthen its credibility. The Rome Statute system will definitely benefit from states using also diplomatic dialogue with other states to promote cooperation between them, as well as to encourage the ratification and full implementation of the Rome Statute. In this context, we note with concern the serious challenges that the Court continues to face regarding its request for cooperation, including in the execution of its arrest warrants. And therefore, we call on states parties to comply with their obligation to cooperate fully with the Court in investigation and prosecution of crimes within its jurisdiction. We face an absolute need to get arrest warrants issued by the Court executed immediately and as a matter of urgency. Without that, ICC cases cannot proceed, as we all know, and the purpose to deliver justice and to deliver it timely risk to be defeated. Italy is ready to offer a contribution by sharing its own experience and cooperation tools in this regard. We also like to recall the obligations under international law and the UN Charter incumbent upon all United Member States, in particular in cases deferred by the Security Council. And now, coming to my conclusion, I would also like to underline the importance of effective procedures and mechanisms enabling states, parties, and other states and institutions to cooperate with the Court. Sorry about that. Cooperate with the Court concerning the identification, tracing and freezing or seizure of proceeds, property and assets as expeditiously as possible. These measures are also key to secure funds for reparation for victims and for providing support to the various programs of reconstruction. Italy has good experience in successfully fighting organized crime, also through specific legislation. We have gathered good experience in financial and economic investigations, in seizure and confiscation of illicit assets, and we are ready to share our experience also with the relevant bodies of the International Criminal Court. Thank you.
Merci beaucoup, Monsieur l'Ambassadeur.
Thank you very much, Ambassador. The next speaker on my list is Belgium. Ambassador. Thank you. I shall give the floor to my colleague, Mr. Renard.
Monsieur le co-facilitateur.
Thank you, co-facilitator. Thank you for giving us the floor again. I shall try to be a bit briefer in my statement than what we had written, but our entire written statement will be published on the website of the Assembly. I would like to begin by thanking the representatives of the court and civil society for their very instructive feedback. I won't go back on the provisions that have been made at national level to improve cooperation with the court when it comes to financial investigations and the seizure of assets, which has often recently been optimized in the Belgian legal framework. We've developed we welcome the establishment of a network of national focal points. We think that this would be one step towards enhancing the efficacy of the court. In 2010, we already called for a mechanism that would make it possible for states to participate in such a mechanism on a voluntary basis. This mechanism could make it easier to share knowledge, skills, best practices amongst the participating states, and it would also offer us a forum where we could address jointly with the court all of the legal challenges that the court faces, and also ways in which national legislation could be enhanced to foster greater cooperation. When it comes to sharing specifics about any cases, that is a very different type of situation since the proceedings are confidential. We fully understand, however, the relevance of the establishment of an operational network for financial investigations, seizure of assets, etc., because this is often coming in the form of orders from the court, as we've just heard. So we are interested in further consultation on this. We want to look at the mandate, the terms of reference, and composition of these focal point networks in order to make sure that we could have the resources that would make it possible for the broadest number of states and even non-states to participate in the Rome Statute system. Thank you very much for your attention. Thank you, Belgium. We shall now hear from civil society. And I would apologize to all of those who asked for the floor. Human Rights Watch, this is a pre-recorded message.
Many thanks for the opportunity to address this plenary on behalf of Human Rights Watch. For as long as the ICC does its job, it will face politicized opposition. State party support, together with civil society and other international partners, is essential in the face of challenges. The removal earlier this year of U.S. sanctions demonstrates our collective strength when it comes to defending justice from political attack. We look to states parties to draw lessons from that experience and to swift implementation of Independent Expert Review Recommendation 169, aimed at ensuring strategic responses to any future attacks. We also look to this Assembly to devote dedicated time in its future agendas to the issue of non-cooperation. We urge states parties to take every opportunity to bring about the arrest of individuals subject to ICC arrest warrants. States parties should remind Libyan authorities of their obligations under a UN Security Council resolution to ensure the surrender of Saif al-Islam Gaddafi. Failure to act blocks access to justice for the victims of serious crimes. And while there have been positive developments in the relationship between Sudan and the court, recent events there have created new challenges. And these events underscore the importance of states parties leveraging all opportunities to call on authorities to respect their obligations and public commitments to cooperate with the court. Without arrests, there can be no justice. And without greater state party engagement, prospects for victims to see justice will remain limited. Thank you.
Merci à Human Rights Watch.
Thank you, Human Rights Watch. Excellencies, ladies and gentlemen, this brings us to the end of our work for this sitting. We focused on two priorities this morning's session and looked at some concrete examples of what has been done. We've also shed light on the challenges that lie ahead still and the approaches that will enable us to rise to them. The parties should strengthen cooperation with the court, making it possible for the court to fulfill its mandate. And the court shall play its central role in fostering legal assistance, making it possible for states to participate insofar as possible. It's on this note that we shall bring to a close this conference session on cooperation. Of course, a lot remains ahead to be done in the field of international cooperation, but it's thanks to conversations like this one that we can set forward the stepping stones that will make progress. I would like to thank my friend and co-facilitator, Mr. Vassi. Thank you very much. Thank you to you all also for attending in such large numbers and participating in the discussions, and also thanks to the interpreters. Thank you.
C'est bon, ma chère. Merci. Merci, mon cher. C'était bien, hein? C'était bien. Bien fait. Merci. Bon, pour le moment, on est en train de... on est en train de pousser. Je sais que c'est pas évident, mais bon. Il faut aller voir tous les Africains. Là, on va le faire, on va le faire. Je vais le faire tout à l'heure. Je vais rester un peu pour ça, d'ailleurs.
Non, moi, je vais passer quelques coups de fil aujourd'hui pour le
S'il te plaît.
soutenir, notamment en gros lac.
S'il te plaît.
Une bonne session.
Hélène. Dis-moi. Non, c'était juste pour dire merci, là. Comme d'habitude. Mon Amazon préféré, là. Oui.